Welcome back to the Deep Dive. Today we're pulling back the curtain on something you might not even know is happening. It's this massive but sort of hidden conflict that's really reshaping how we all access knowledge. We're talking about the battle between libraries and publishers.
It's a quiet war, for sure. And it's all about the digital lending problem.
Mm.
You grew up, you went to the library, they had a book, you could borrow it, simple. That physical book could be lent out forever, basically.
Right, but now try to do that with an ebook. Suddenly the library isn't buying a book, they're, renting a license, and they're paying maybe 4, even 5 times what you would pay for something that just vanishes after a couple of years.
It vanishes. And that's the crisis. The whole mission of a library is to, preserve and provide access. And that is being choked by this move from physical ownership to revocable digital licensing. So our mission today is to really unpack all of that for you. We'll get into the history, the legal fights, this thing called controlled digital lending.
And the insane costs and clauses in these contracts.
Yeah, and we'll even look at some of the loopholes and tech solutions libraries are trying to use just to stay afloat.
Okay, let's get into it. To really get why the digital world is so, I guess, hostile to libraries, we have to start with the old physical world. We have to talk about something called the first sale doctrine.
Right, or copyright exhaustion. It's a really simple but incredibly powerful idea. In the U.S., it's actually written right into the Copyright Act. And all it says is that once the creator sells a physical copy of their work—
a book, a CD, whatever.
Exactly. Once they sell that specific item, their control over that item's distribution is, well, it's exhausted. It's done.
So they get paid once, and after that, I can lend the book I bought to a friend, or I can sell it to a used bookstore. Or if I'm a library, I can lend it out for 100 years.
Precisely. And that's the foundation for libraries in places like the US, Japan, India. But here's the part that most people miss, and it's kind of the genius of the old system. It all worked because of what economists call frictions.
Frictions. Okay, that's really interesting because we usually think of friction as a bad thing, something you want to eliminate. But you're saying these inefficiencies were actually essential.
Absolutely essential. I mean, think about using a traditional library. You have to physically go there, you have to find the book, check it out, bring it home.
And then you have to bring it back on time or you get a fine.
Right. And the book itself gets old, it gets torn, it degrades. All of that is friction. And that inconvenience, it actually serves a really important social purpose.
Oh, so?
It splits the market. The people who value convenience and speed, who want the book now and want to keep it forever, they're usually the ones who can afford it. So they're nudged to just go and buy the book.
So the friction makes sure the library is mainly serving people who probably wouldn't have bought the book anyway.
Yeah.
So it doesn't really hurt the publisher's main market.
Exactly. It minimizes the harm. The publisher sells to the convenience market, and the library serves the access market. It was a beautiful, functional equilibrium. It worked for everyone.
But the second you go digital, all that friction, that whole equilibrium, it just evaporates.
Instantly gone. And the legal ground shifts completely under your feet. Because the first sale doctrine, it just doesn't apply to a digital file.
Why not? That seems like the key question.
Because the doctrine only covers the distribution of a physical copy. But when you download an ebook from a library, the law doesn't see that as a simple transfer. It sees it as making a reproduction. A brand new copy of the work is created on your device.
Wow. Okay, so that one little click, the download button, is legally considered making a new product. And that violates the copyright holder's rights unless they've given specific permission.
That's the whole ballgame. That's the switch from ownership to permission. And because libraries can't just buy an ebook from Amazon and lend it out, they lose all their bargaining power. They're completely cornered.
And when you're cornered, you get hit with massive price discrimination. We're not talking a few extra dollars. We're talking 3, 4, 5 times what a normal person pays for the same file.
It's basically a tax on public access. And on top of the cost, you have the terms of the license itself. A physical book might cost $30 and last for decades. An ebook license could cost over $100 and it might only last for 24 months.
Or, 26 checkouts, and then you have to buy it all over again. You're not building a collection, you're just treading water, renting bestsellers.
You're on a hamster wheel. And this model creates this terrifying idea of fragile access, not just for libraries, but for you, for everyone. When you buy a digital product, you're really just getting conditional access, and that condition can be revoked.
Conditional access.
Yeah.
That sounds a bit academic, but it has some really scary real-world consequences.
Oh, absolutely. I mean, do you remember that story about Amazon and George Orwell's books? They remotely reached into people's Kindles and just deleted the copies of 1984 and Animal Farm that people thought they'd bought.
Wait, I remember that. A company can just delete something I paid for my device without my consent.
They did. It turned out the seller didn't have the proper rights, so Amazon just banished them from everyone's accounts. That is the perfect illustration of a license versus ownership.
And we saw it again with things like Google Stadia,
Yep.
right? The whole gaming platform shut down.
And every single game people had purchased was just gone because the license framework they existed on disappeared. That's the fragility that libraries are trying to fight against.
Okay, so this crisis obviously demanded some kind of counter move from libraries, which brings us to controlled digital lending, CDL.
Yes, CDL. This is the library world's attempt to kind of recreate that old physical friction, but for the digital age. The basic idea is pretty straightforward. A library owns one physical copy of a book, they scan it, then they lock the physical book away so it can't be borrowed.
So they maintain that 1-to-1 ratio, one book they own, one person borrowing it.
Exactly. It's the one copy, one user model.
Right.
One digital copy gets loaned out to one person at a time.
And the argument is that since the economic effect is the same as physical lending, it should be considered fair use. It's not hurting the publisher's bottom line.
That was the theory. And it got a huge test in court. The big case was Hachette Book Group v. the Internet Archive.
Right, the Internet Archive was doing this on a massive scale, and the publishers sued.
They did. And in March of 2023, the court ruled against the Internet Archive. It was a huge blow for CDL.
So if the one-to-one logic seems so sound, why did the court reject it?
The court basically bought the publisher's main argument, which was that the Internet Archive's CDL program wasn't just filling a gap. It was directly supplanting the publisher's own market for library ebook licenses.
Ah, so because publishers were already selling expensive licenses to libraries, the court saw CDL as an unauthorized competitor, not a fair use.
Exactly, a non-transformative substitute.
But the whole point of fair use is that it's supposed to adapt to new technology to keep the balance in copyright.
And that's the core of the appeal. The argument is that a properly designed CDL, maybe one that only uses older books, or one that deliberately adds digital friction.
Like slowing down the lending speed or something.
Yeah, something like that. They argue that kind of system would be fair use because it would mimic the old market segmentation. It wouldn't compete with new bestsellers.
What about in Europe? Are they having any more luck?
Europe is. Well, it's a fascinating catch-22. On the one hand, they got this huge win in 2016, a case called VOB v. Stichting Leenrecht. The European Court of Justice basically said, yes, one copy, one user digital lending is legal under national law.
Okay, so that sounds great for libraries. Problem solved.
Half the problem solved.
Yeah.
Because then, in 2019, in another case, the same court said that the first sale doctrine does not apply to ebooks.
Oh.
So a library in the EU has the legal right to lend a digital book, but they have no legal way to get that digital book in the first place other than
Through the same expensive, restrictive publisher licenses they were trying to get away from?
it's a perfect trap. Which brings us right back to that power imbalance. That Communera report really lays out how publishers use their monopoly power. First, there's just flat-out refusal to deal. Publishers will simply refuse to license popular books or critical textbooks to libraries at all.
Forcing students or patrons to just buy them.
Right. And when they do offer licenses, the models are, frankly, predatory. They'll force a university library into a one book per student model for a required textbook. A library might have to buy hundreds of licenses.
That's completely unsustainable. And I read there are privacy issues, too.
Huge privacy issues. Sometimes the contracts require the library to hand over lists of the students using the book. For a public institution, that's a massive red flag. And then there are the restrictive clauses buried in the contracts.
Like making the library liable for what users do.
Yes, and these new clauses around AI and data mining, they're a huge deal. The contracts will say that the licensed material can't be used with generative AI, so a student can't even ask a chatbot to summarize a paper they have legal access to.
So the library is paying for access to information, but the license forbids using modern tools to analyze that information.
It's licensing the data but restricting the tools. It's absurd. And they'll add choice of law clauses, saying the contract is governed by Delaware law to get around more favorable research rights in, say, the EU.
So if legal challenges like Maryland's ebook fairness law get shot down by federal courts, is there any leverage left for libraries?
There is one tiny, very interesting constitutional loophole for state-run institutions.
Sovereign immunity.
Exactly. The Supreme Court has affirmed that states have 11th Amendment sovereign immunity from being sued for financial damages under federal copyright law.
So a state university library is a bit of a shield.
It gives them significant leeway. If they experiment with a borderline CDL scheme, the worst that can probably happen is a court tells them to stop, an injunction. They're not going to get hit with millions in damages that could bankrupt them. It lowers the risk of innovation.
Okay, so that's the legal side. What about technology? Can tech offer a way out of this mess?
It might. People are looking very seriously at blockchain technology as a potential alternative to the current vendor system.
Blockchain. How would that work for a library?
Well, it wouldn't change the law, but it could change the infrastructure. A blockchain is an immutable, transparent ledger. You could use it to create a tamper-proof record of ownership and usage rights for a digital book.
So instead of your ownership living on a company's server, which could shut down, it's recorded on a decentralized permanent ledger.
Precisely. It brings a level of trust and permanence back into a system that's currently defined by revocable permission from a central authority. It could streamline interlibrary loans, track funding. It has a lot of potential.
This whole deep dive really just exposes this fundamental tension, doesn't it?
It really does. It's the need to incentivize creators through copyright, which is valid, versus the need for broad public access, which is vital, especially for those who can't afford to pay.
So what does this all mean for you listening? This digital lending problem, it really forces us all to ask what the role of a public institution like a library is supposed to be when physical ownership is no longer a given.
And that leaves us with a final thought for you to chew on. When libraries have to spend their very limited budgets on these super expensive short-term licenses for bestsellers, just to keep people coming in the door, what happens to their other mission? Building deep, permanent collections for research and preserving knowledge for the long term. Is that mission being compromised?
And if all access to knowledge becomes purely permission-based, something that can be revoked at any time, what have we as a society really lost? What was the public good that physical ownership always guaranteed?